Okay. Imputation of income. I realized my slides are a bit out of order because I have some more parenting stuff below. But anyway, I wanted to talk about this because there's a couple BC Court of Appeal cases, this one being French and French. The parties were involved in a family law proceeding a few years before, and they dealt with the division of property and then spousal support. And the wife, a few years later, brought an appeal of the decision around particularly spousal support, alleging that the judge had erred in calculating the support payable to her because the judge based it on imputing income to her prior to a motor vehicle injury she had sustained, which left her unable to work. So the judge acknowledged, yes, the wife can't work now due to a medical condition, but hey, still attributed a pre-accident income to the wife, which then reduced her entitlement to spousal support to zero. And the reason the judge did so was because the judge said, well, at some point you're going to get compensated by ICBC. Well, who knows nowadays with what's going on with that system, so that she would get that income back for that sort of lost income. And that was the expectation. So therefore, basically imputed that income to the wife, said, oh, well, that she has this amount of income, even though she didn't have that money at all in pocket, and there was no timeline which she was actually going to receive any compensation, or if she was actually going to be fully compensated for her loss of income. I digress. But the judge says, yeah, I'm gonna give you that income. The Court of Appeal says that's wrong. That's an error in setting the wife's income at that pre-accident level on some expectation that she presumably would be compensated for loss of income. The court held that the prospect of reimbursement at some point in the distant future, and they use those words, in some point in the distant future, does not represent a proper basis for imputing income to someone who has not received that income. And so the Court of Appeal allowed the wife's appeal. So courts are very mindful about things that are speculative, right? They want real evidence, real and now, that can be substantiated. And so this is a case where it's speculative that the wife is going to get money back, and therefore she doesn't, and once she gets all that money back, she doesn't need support. Even if it was going to be like, 4 years from now, she has zero income now anyway. So the Court of Appeal fixed that. Here's another case of imputation of income. This case, M.F.W. and M.A.H, Mr. Justice Basran. So after a trial in 2019, the husband was ordered to pay child support and spousal support on an annual income of $170,000, which was derived primarily from a company he had invested in. And he had inherited several $1 million of assets, which included this company a year prior to the end of the marriage. And then in December 2020, he was laid off from the company, and he sought to reduce his support payments and cancel arrears. He basically, I got zero. Hey, oh, there we go. Oops. The court denied the husband's application. Mr. Justice Basran noted that this is always the one, when you fill in the financial statements, had $67,000 of annual income, but had $13,000 in monthly expenses. I don't know why they didn't do the math. What's 13 times 12? Anyway, it's a lot more than $67,000. So, and there was no corresponding increase in debt, right? So either the father was lying about his expenses, or he had a lot more income, or the husband had a lot more income than was stated, right? He also couldn't give, or didn't give, any proper explanation why his assets were worth millions of dollars, seemingly generated no income, right? So that raises a lot of red flags. And then in terms of his health, the husband failed to prove that his health problems impaired his capacity to work. He had worked as a heavy equipment operator and in construction, and there wasn't enough healthcare medical evidence to show he couldn't continue to work in that capacity or in anything else. So the judge found that the husband was deliberately underemployed and imputed not the $170,000, but $125,000 to the husband. So there was an acknowledgement by the court that his income went down, but not basically to zero, which is pretty much what the husband had wanted. And no income was imputed to the wife. Regarding canceling arrears, which the husband had wanted, Mr. Justice Basran held that despite the significant decline in his income, this is again what the Supreme Court talked about in Colucci, it has to be long-standing, not just right now there's a decline in income and there's just no cash to pay it. So it's uncertain that it would be longstanding, and there was a paucity of evidence of the husband's efforts to obtain employment. And also, given his lack of financial disclosure, the judge wasn't satisfied that it would be grossly unfair not to cancel or reduce the arrears owing. Grossly unfair, of course, that's the test that continues to go for him. So that's another one about somebody being underemployed, a case that if you want to rely on, there it is. Okay, this